Second. Okay, so welcome everyone. My name is Todd Wohl. I'm one of the partners at Braun International and Premier Estates, and we are the hosts and founders of the Fiduciary Education Forum. Our website is fiduciaryforum.com. This presentation will be recorded and the video will be on the fiduciaryforum.com website as well as the presentation itself. Our fiduciary forum puts on Zoom events with educational topics once to twice a month, every month. And we've been doing this for about 3.5 years. And I'm really pleased to present experts in their field, topics that we feel are very relevant to our clients and and uh, and really prescient in situations that we all tend to deal with. And um, I want to say Happy New Year to everybody. And I'm honored to have quite a panel today, and um, with John Kim and Sharon Weiss and Erin Brooks. They were kind enough to take their time out and work to put this presentation together. So I'm going to start with Sharon. Sharon, would you introduce yourself really quickly to everybody?
Yes, thank you, Todd, and thank you for the opportunity to let us be part of this program. It's very exciting for us.
Thank
My
you.
name is Sharon Weiss. I'm a partner in the Santa Monica or Los Angeles office of Bryan, Leighton, Paisner. I am a classic uh, bankruptcy lawyer, and what I mean by that is I do all aspects. I do debtor work, creditor work, buyer, seller, you name it. I've done it. And lately, I've found myself in more and more situations dealing with environmentally challenged assets. So I regularly recruit Erin, my partner from Chicago, who'll introduce herself, to save the day. And I'm, like I said, excited to be here this morning.
Thank you, Sharon. Erin, how about yourself?
Great. Thank you, Todd. Thank you, Sharon. Good afternoon from Chicago. My name is Erin Brooks. I'm a full-time environmental lawyer at BCLP. I'm also the office managing partner of Chicago, so wear a couple hats like many of you, I'm sure, do. In the environmental space, I spend a lot of my time on distressed assets. That can be helping with compliance issues, brownfield redevelopment, and working to mitigate the risks for owners, operators, prospective purchasers, and of course, fiduciaries kind of across the board. So really appreciate the opportunity, Todd, and look forward to a good conversation.
Thank you. Thank you. And John, the
Thanks,
star.
Todd. Happy New Year, everyone. My name is John Kim. I'm a Senior Vice President at CAC Specialty. We're a specialty broker, and my sole focus is environmental insurance. I'm based here in San Francisco. I've been on the brokerage side for about 20 years, and then prior to that, I have a technical background, both in education and worked as an environmental underwriter as well as an environmental consultant for many years.
Okay. Well, thank you all. So we're going to get right into the presentation. And those of you who are joining us, the chat room will be open. We'll try to address questions as they come in, or at the end, we will have a few minutes for Q&A. So the title, as you all see on your screen, is Toxic Assets, Strategic Solutions, the Fiduciary's Guide to Environmentally Impacted Real Estate and What to Do. So let's see. Um, eh, Sharon, Erin, I'll let you start with the
I'll take the
introduction,
first. I'll take the first leap here. We
please.
and just so everyone knows, we are going to go a little bit out of order from the slides, and we do have updated slides that provide a little bit more information. Um, this presentation, there's so much information in this subject area that there is absolutely no way we could cover it in an hour, let alone maybe a day. So we're going to be super high level, but we're all available for questions after the presentation. But generally speaking, what we're going to focus on today is the assets themselves, these environmentally challenging assets, specifically real estate, and the conflict between bankruptcy law and environmental law, and how we have tools, whether it's in bankruptcy or distress situations or under federal or state law, notwithstanding having a distress process, to help liquidate and monetize these assets. And one of the things that you will hear, and I'm just going to tell you right now, John is going to be such an important resource regarding insurance, and it's going to blow you away. So make sure to stay to the very end, because his is going to be the most interesting, I promise. So with that, I was hoping to turn it over to Erin, who will give a very high level primer on environmental law that we're going to need to be the background of our discussion this morning.
Great. Sharon, thank you so much. And I'm happy to be second is exciting to John and fully agree with that. So just to kind of frame the conversation a little bit, why do we care about the environmental risks? Some of this might be basic to some of you. Some of it might be some nuance. So I'm going to start from a 30,000-foot view and just offer some basic guidance that I think is going to help frame the conversation. So when we think about environmental liability, the reason that we really care is there are federal and state statutes that are no fault. That means that an owner or operator of contaminated property can be held liable. And just bear with me for this kind of intro. We're going to go off slides, but as Sharon said, we're going to supplement our slides, so you'll see this in writing, but bear with me as we kind of give the primer without any visual aid. So in terms of environmental liabilities, we think about the real estate itself, the soil, the groundwater, the water itself, the air. We think about tanks and other infrastructure that can contain hazardous chemicals. Sounds like we might be getting some feedback.
Go ahead. We got it.
We
I took care
fixed
of
it.
it. Go ahead.
Jonathan fixed it. We could just call him out on it.
Yep.
Thank you, Todd.
Go ahead.
And with all of these things, there is a very broad variety of laws that govern it. For purposes of today's conversation, we're going to zoom in on one specific type of law, which is CERCLA. You might also hear that as Superfund. It's one and the same. That's where we get this idea of no faults liability, that an owner or operator can be liable for contamination, even if they had nothing to do with it. A lot of states also impose similar types of liability. And the reasoning makes some sense. These laws came into existence 45, 50 years ago for the purpose of ensuring that a user of a property is responsible for the things that happen on it, so that a bad actor can't cause contamination, go away, and let it be somebody else's problem. But because of that, being in the chain of title or the chain of operating can create some real risk and real exposure. And that includes in fiduciary settings, which is why we thought this might be an interesting topic to get into. So take that premise with me for a second, that an owner or operator can be held liable for anything on the property. That's really a cornerstone here. That means that if there is contamination and it needs to be cleaned up, investigated, if it goes off site, that liability can attach. Because it is not fault-based, it is attached to your status, there are very few defenses. There is one very important defense, though, that I will mention, and this is going to be more relevant in the instance where you are taking title to a property or taking a lease to a property, which might be kind of a skinny variety of the transactions that you all encounter. But that's the bona fide prospective purchaser defense. Phase 1 environmental reports are bread and butter for what John and I do on a daily basis. And getting a Phase 1 report is a very important part to the bona fide prospective purchaser defense. That is one core tenet and one reason that these reports are obtained, and that helps to provide some statutory defense. That could be an entire separate seminar, and if anyone has questions on Phase 1 reports, always glad to take that offline, but I wanted to put a seed in that in terms of the discussion here today on transacting in a fiduciary setting. There's also other types of liabilities that come up. So it's not just the cleanup costs for contamination. If the contamination goes off site and it impacts another property, and that property owner has an alleged illness due to exposure, if their property value goes down because of that impact, those are also environmental liabilities that can come up in the contaminated land space. And those are exactly the types of risks that John Kim is thinking about every day as he's working on insurance policies and every day that we're working on to help identify and mitigate those risks. And we'll talk about some of the risk mitigation, but I want for this team to be thinking about those types of buckets of risks in the context of transacting on these sites. There's another concept here that I think is maybe a little bit more relevant for this group, which is the statutory liability under CERCLA can attach to lenders and secured creditors. Thankfully, Congress thought about that when they passed CERCLA, and many of you might be familiar with these concepts, but there is a secured creditor exception to CERCLA liability, which basically provides that if you are a secured creditor and you do not participate in the management of the facility, you just hold the indicia of ownership to protect your security interest, there's a protection from liability. So what's really important on that is not stepping into the operations of the facility. If you step into the operations, that defense goes away. If you're a secured creditor and you're not operating the facility and you're not engaged in the management, you can keep that defense, and that's incredibly important. The other point that I want to highlight before we get into some of the more transactional considerations is foreclosure. So I mentioned up top that a current owner can be held responsible for any of the environmental conditions. So that might have triggered for a few of you, well, what if I take title because of a foreclosure or a non-judicial foreclosure sale or a deed in lieu or repossession? It applies equally to all those categories of transactions. And here is the key. To retain secured creditor protection after foreclosure, you need to continue to sell, remarket, divest the property. You can't sit on it and expect to hold that defense. So the terminology I'm quoting here is at the earliest practicable, commercially reasonable time on commercially reasonable terms, taking into account market conditions and legal and regulatory requirements. In other words, if you foreclose or go through any of the other transactions that I mentioned, take steps to get rid of the property as soon as you can. You can protect your interests as a secured creditor. There are aspects of environmental insurance that can be underwritten to secured creditors and mortgages and other types of secured transactions, and we can provide some information on that. But just in terms of kind of setting the table for why do we care about the environmental considerations from a legal perspective, these are some of the keys. So there are some tricks of the trade. They're not bulletproof. You got to play by the rules. So against that backdrop, I think we can transition to a little bit more conversation around the types of insolvency tools, Sharon, and how do we use these insolvency tools to mitigate against those key risks that I just outlined for the team here.
Todd, did you have a question before I start?
But the only thing I wanted to add regarding what is commercially reasonable when it comes to sale, from our perspective as brokers or as real estate auction experts, it is a very common question we get from Sharon or Erin or any professional that is in the chain of sale process. Commercially reasonableness will depend on the type of property, the locale of the property, the issues surrounding the property. When we're in front of a judge, many judges will say to us, 14 to 21 days of marketing in their book is commercially reasonable. We take a different perspective, and that perspective is generally a longer term, depending on the sale process, because it does take quite a bit of time to globally find buyers and to get them to do their due diligence, underwriting, and so on. So that question of what is commercially reasonable for us is on a case-by-case basis. That is, we adjust to the facts. That's all. So I'll let you go. Thank you, Sharon.
Well, and Sharon, before you pick it up there, I think that's an excellent point. And the point that I amplify from an environmental law perspective is your buyer is going to be thinking about all of those things too. Do they have time to do a phase one?
Yeah.
Do their all appropriate inquiries, their due diligence? So Todd, exactly to that point, that the buyer's needs are going to help drive that too, which ultimately should factor into the commercial reasonableness. But you're exactly right. That's going to be in the balancing scales too.
Well, I mean, one other thing, when you talk about phase ones, phase twos, cost to remediate reports, all of those things, depending on who the client is, we request or require those are done in advance, so we have them in the data room. But for some clients, we don't want to get those in advance because of their lack of knowledge liability issues. Therefore, that might be done during the process by a buyer. Um, and we've also found that some buyers, even more sophisticated ones, don't like relying on the reports that we provide or the seller provides from whatever phase one company, whatever environmental company. They want to hire their own professional to do the work their way, whatever that might be. That becomes a little bit of a complication. Other than that, keep on going. Thank you.
No, and that's actually a very good segue here. I just to set the table a little bit. We're kind of talking about these assets in the high level, but from a real perspective, the kinds of assets that are typically subject to environmental issues, distressed or otherwise, are things like gas stations, dry
Yep.
cleaning businesses. Right now, I'm dealing with uh, a lot where an airline company fixes engines and they've been there
Right.
forever, right?
Hmm.
So there's obvious ones and not so obvious ones, but the biggest tool, like the biggest takeaway that I can give you from an insolvency perspective is do not put your head in the sand. Whether you are the trustee, whether you're the buyer,
Yeah.
whether you're the seller, this is not a situation where knowing less is better. You will have no plausible deniability because it is all statutory, well, mostly statutory based. So the most important thing you have at your disposal is the ability to find out information. Now, Todd, I totally understand buyers may want to hire their own professionals, but having, in my opinion, having that information available and making buyers aware that there could be an
Yes.
issue is actually in everyone's best interest. And we'll see that in a minute. So
So
just
let me ask you, Sharon, a question, or Aaron. Let's say we're talking about the owner of the property is an entity or an individual or a number of individuals, either way. And now a third party is brought in, and I'm not necessarily speaking about a bankruptcy trustee or a
right.
receiver. I'm speaking about a court appointed or not a court appointed trustee or successor trustee who knows absolutely nothing about the property, absolutely nothing about the business that was there. They don't know nothing. So my question to you is, to both of you, is it from that person's perspective still important for them to get those types of reports and be aware of and have knowledge to the property issues or not? That's the question.
From an insolvency perspective, or let me, when I say insolvency,
Non-insolvency.
I mean distressed asset perspective,
Yes, non-insolvency.
not a bankruptcy perspective, but
Correct.
from any perspective, the answer to my question would be yes, you need to do due diligence because there's a split in cases as to whether or not the fiduciary who takes over as the owner or the occupier is going to have personal liability. Now, some
Mm.
cases, and most of the cases, especially in a bankruptcy case, will limit that liability to whatever the estate can indemnify. But it's still not clear cut that when you're the fiduciary of a distressed asset, that you're not going to have that personal liability, even though you're working in a fiduciary capacity. So knowing what your exposure is very,
Uh,
very important here, and not something for the light heart. And in a bankruptcy situation, again, I'm not trying to just focus on bankruptcy, but in a bankruptcy situation, you can't just abandon the asset either.
right. Right.
So there are a number of tools. Like, don't get scared. We have ways to help this, but putting your head in the sand is not one of them. I don't know if Erin has a different perspective.
Yeah, from an environmental perspective, knowledge is power. I saw John, Kim nodding as well. You know, to help your buyer do due diligence, to procure environmental insurance, knowledge is power. There's very little value in my mind on being ignorant. And to round out the point a little bit in terms of a buyer's third-party advisors, the buyer, to get the statutory protections I mentioned, has to get a compliant phase one that's issued within 6 months of taking title. Prior to that, checks all the boxes. So you may not be able to provide a phase one that does that, and the buyer wouldn't be able to get defenses. So on some level, your own knowledge is important, and making your buyer have access to all the knowledge and information too is important for those reasons as well.
Okay, well said. I'll let you move forward with the presentation. Thank you.
Oh, and Todd, we happen to love these questions as we go along. So even if we don't get to everything, I think this helps make it interesting to people, and obviously you're asking the relevant questions. This slide is really just a preview or an overview of the different insolvency types there are, right? So we have bankruptcy, receivership, assignment for the benefit of creditor, and out-of-court workouts. I think we can move to the next slide because this is just an identification of the different scenarios. I am specifically dealing mostly with what happens and the advantages of being and problems of being in a bankruptcy case. So one of the issues that a fiduciary should consider, even if they're not appointed through the bankruptcy system, is whether or not they want to be in a bankruptcy case, right? There's always a question of whether we want to put a case into a bankruptcy case. And then the other question is whether a fiduciary even wants to take the engagement. So we're going a little bit into some bankruptcy rules here, and you'll understand in a few minutes why, I hope. There's basically 5 bankruptcy concepts that do have bearing outside of bankruptcy. But from a bankruptcy world, we're talking about whether or not the debt can be dischargeable, whether it's subject to a permanent injunction that would prevent a third party, including the government, from pursuing actions. One is the automatic stay, which is one of the most important protections anyone has in a bankruptcy case that would prevent enforcement of any environmental issue. You're going to see that's not 100%. Another one is lien perfection, and whether or not things like a super lien that Erin will explain a little bit later can be perfected even after a bankruptcy case is filed. Fourth, and probably most importantly for this group, is the sale of property. And fifth is abandonment. So those are the big sections that I'm going to be discussing. And again, feel free to chime in anytime you want. So go to the next slide. Oops.
Sorry, there you go.
That's okay. So the first thing I'm dealing with is dischargeability, whether there can be a permanent injunction. When we talked about not putting your head in the sand, this is an example of why not. So the most important thing to establish from the onset is whether or not there's a quote claim in the bankruptcy case, whether or not a bankruptcy or an ABC or a receivership. I think this would probably apply across the board. But the first question is whether you have something to deal with in that insolvent state of mind, or in that environment, right? So the question is whether you have a claim, and in order to have a claim, it has to have occurred before the bankruptcy case or before confirmation, and notice is a key. Notice. I mean, notice is a key for anything in an insolvency situation. It's even more important under these circumstances. So if you go to the next slide, I'm going to try to keep this super high level. Todd, go to the next slide. Okay, so there's 2 tests. So, some in the Ninth Circuit and some outside of the Ninth Circuit. There's the pre-petition relationship test to determine whether or not you have a claim, and the other is the fair contemplation test. In the Ninth Circuit, we follow the fair contemplation test. Other circuits, like, of course, I just lost this from my notes. other circuits like the 11th Circuit follow the pre-petition relationship test. The basic difference between the two of them is regarding the scope and the timing requirements of when a claim arises. The fair contemplation test focuses on whether or not the parties could reasonably anticipate potential claims at the time of the bankruptcy filing, regardless of whether there was a formal relationship between the parties. Where, in contrast, the pre-petition relationship test requires an actual connection between the debtor and claimant before the claim can arise in a bankruptcy case. So, if you go to the next slide, this is a hot primer of the difference. So the pre-petition relationship test is harder because you need to show that there is a relationship between the claimant and the debtor. There has to be something there. Or if you go to the next slide, the fair contemplation test, which is the test under Jensen in the 9th Circuit, is whether or not you could know. So in a case that I have, one of the biggest pieces of advice I gave our client is take good notes. Has there been a demand from any environmental agency that you're put on notice? Is there any reason, anything you can show that shows that the property may be subject to an environmental issue is good here, because it shows that it happened before the bankruptcy was filed or the insolvency was done, and now you have a claim that you can deal with in a bankruptcy case. It may or may not be dischargeable, but at least you have the foundation to know that you have something you could deal with as opposed to not deal with. That first slide that I had you skip over were just kind of general examples and some broader ideas. So we can go to the next slide. Now, also in the bucket of claims is we have our pre-petition claim, things that happen before the bankruptcy. And as every good fiduciary knows, it's those admin claims, the after bankruptcy claims that will come and bite you in the tush because they have the higher priority outside of secured claims. And the question then becomes whether or not an environmental claim would have priority. And the answer is it depends. If, just like any other administrative claim, if the cost is actual and necessary to preserving the estate, or it provides a benefit to the estate, then yes, and that claim may be it's probably entitled to administrative expense. But if it's just done to be done, and there's no real reason for it, then there's an argument that claim is not an administrative claim. So I just wanted to touch on that because in any insolvency proceeding, we always deal with priorities, right? What comes first, what gets second, what goes third. And so these issues help us identify where something's going to fall in the stack. Okay, so if you go to the next slide. Okay, so the automatic stay, as I said before, is probably one of the most important powers that there is in a bankruptcy case. It's not available in other insolvency proceedings. So this is one reason to consider a bankruptcy proceeding is whether or not you can take advantage of the automatic stay. However, it has two important exceptions when we're talking about environmental issues. One is whether or not this is a government claim that's exercising a police power. And the other is the perfection of a lien. So if you go to the next slide, Todd, this again outlines the two key exceptions to the automatic stay that matter in these types of cases. And go to the next slide. So this slide is dealing with the police power, and there are two tests. I think it's on the next slide. There are two tests that, nope, sorry, go back. I lied. There are two tests that matter, that either of them can be used to determine whether or not the automatic stay applies. One is the pecuniary purpose test, and the other is the public policy test. And like I said before, either of these apply in the 9th Circuit. The pecuniary purpose test examines whether or not the government action relates primarily to protecting the government's pecuniary interest, meaning whether it's really to enforce a monetary issue or is it really there for the protection of health and safety. If it's there for the protection of health and safety, then the police power exception applies and the automatic stay would not apply. The public policy test determines whether or not the government is seeking to effectuate public policy. And it's really to prevent a private right of action where an individual saying, well, they spent money or they did something under a private right of action, but it really doesn't have a basis in the public policy. So the primary test that's used for this is the pecuniary purpose test. And the catch here is that there usually will be a pecuniary purpose unless you can show it's totally monetary. So if the government's just trying to collect money, the automatic stay will apply. If the government is trying to protect health and safety, then it won't. So for example, this is in a little bit of a different situation, but I had a situation dealing with building permits and whether or not the rules apply to a distressed piece of property regarding inspections and all of those kinds of things dealing with building permits. And we didn't have the court adjudicate the issue, but at the end of the day, what we decided is anything that deals with safety, we as the debtor agreed that the government can do whatever it wanted to do, but it couldn't enforce any judgment. It couldn't enforce penalty. It couldn't enforce any of those monetary obligations, but it can continue to monitor and make sure that the property was safe for public use. Okay, so next slide. Again, this is just a quick primer on how to kind of easily assess whether or not or not easily, but try to assess whether or not the automatic stay applies. So let's go to our next slide. This is a repeat, so keep going. Okay, so this is dealing with the enforcement or the perfection of a lien. And the issues really regarding the perfection of a lien. And for that, I'm going to turn back to Erin to explain what a super lien is.
Yeah, thank you so much, Sharon. So coming back to the comments that I opened with, a party, that could be a government agency, it could also be a private party, maybe in a position where no one else is addressing contamination, and they need to take some action to avoid an imminent threat to health or the environment. So if that party starts to do remediation work, they're going to come out of pocket for that. In that instance, and this is purely a creature of statute, there is a statutory lien right under federal CERCLA, and then many states have their own versions too. The idea is once a party, again, a government agency or a private party starts to incur response costs, they can effectively record a lien against the property that takes priority, and it becomes a first priority lien that, to Sharon's point, overrides other secured creditors on the chain of any other liens and outstanding debts that are there. So this is important because what that is granting is the ability for a self-help right for those parties to step in and incur those costs, charge them back to the property against any other creditors who are standing in line trying to get paid. So identifying liens and super liens in the environmental space is very important because they can take priority. And so if that is an opportunity in due diligence to identify if that's a risk for property that you may be having a fiduciary responsibility with respect to, strongly encourage due diligence on that, because that is going to be a very fundamental thing. If there's a lien recorded, it could have really important implications. And John, on that point, I don't know if there's any insurance available for liens or if this is something where you just get in line.
Yeah, I think it depends on the actual case, but you can insure against these types of situations where there is a lien. It just kind of depends on the property and who the lien holder is.
So Erin, you and I did discuss this, but when someone's investing money or spending money on a property for environmental cleanup purposes, do they have to, like with the mechanics lien, you would have to record that ahead of time, right? There's some kind of way to do due diligence on that. Does that exist? Does that exist here?
Yeah, the liens are typically recorded. And again, because it's a creature of statute, it's very important that it could come up in state statutes or federal statutes. But Sharon, exactly, it would be recorded. So a standard title search should, in theory, identify it. What you want to make sure is that the title search would cover environmental liens specifically. Some providers have that as kind of an add-on, a built-on component. Some have it within the standard scope. So that's something to clarify with the title company. But that's the due diligence tool that you would use for that.
Right.
Erin, is that generally included in the ASTM for the phase ones? Do they evaluate whether these properties have environmental liens?
Great question, John. So the phase one report is supposed to do that. What happens though as a practical matter is the environmental consultant says, well, we didn't get a title report, so we didn't look into it.
Right.
So that's really the key, John, that you're hitting on is the environmental consultant could, if they're asked and paid to do that. Typically what we see in practice is the party who is getting the phase one report hires a separate title company to run that search. But again, you could ask the environmental consultant to, just don't bank on the fact that they're going to.
One thing I'll add, when we do on the appraisal side of our business, when we're doing appraisals for environmentally impacted properties, one of the first things we do, other than ask for the phase one, the phase two, the cost to remediate, we will actually pull a title report ourselves and make sure that the information that we show on title is correct, and there aren't things there that may impact the valuation that the client may not be aware of, and which means they wouldn't have told us. So we pull a PTR right away in that situation.
Yeah, I mean, I see this as important as finding out if there's mechanic liens or title issues. I mean, this is part of that package. What I wanted Erin just to touch about for like maybe a minute is, what is the role of an environmental consultant? Like, when do you know to hire one? What do they do? Because I don't know if everyone here I knows what the function of environmental consultant does. And apologies, you guys, I'm losing my voice, so sorry if I'm sounding like a frog.
No, thanks, Sharon. And I see we've got a couple environmental consultants on it. Hello, Tim Bradburn and a couple others. Really glad to see you on today. An environmental consultant can do a lot of different things. For purposes of diligence, their most important role is doing the phase one report, which is pulling together a lot of things. They're going on site and physically reviewing things. They're doing interviews with the site owner. They are pulling database records, which is separate from a title search. It's environmental databases on, is there a record of a spill? Is there a record of a notice of violation? They're pulling all of those things together. But the really important thing for a phase one is it's not invasive. It is not going to do environmental sampling. There's not going to be holes in the ground. There's not going to be sampling on the building materials. But that phase two work or building materials assessment, environmental consulting firms can also do that. And then you take that one step further, in addition to the due diligence on a desktop basis, going to the site, doing the sampling, they will also help with the investigation and remediation of any contamination. So if there were a soil issue or a groundwater issue, you could call Tim's team, for example, and ask them to develop an opinion in terms of what kind of remedial technologies would work for the contamination, develop a cost estimate. And to that point, that's also an important function, is sometimes, especially on bigger deal environmental properties, we represent buyers who might want to understand what they're getting into from a remediation cost. And so the consulting firms can also help try to quantify it and put a price tag on that in terms of what the exposure might be before you actually go down that page. But on an ongoing investigation or remediation project, I mean, these are projects that can last decades because of the nature of the constituent. So if you wind up with a matter that needs remediation, it can wind up being a very long-term project with a pretty good carry cost from a reserve balance sheet perspective.
Yeah, and just to add to that, from the non-environmental lawyer perspective, your environmental consultant is, from what I've seen, is pretty key because they help formulate the plan to make the property work, right? And they also engaged, in my experience, with the governmental agencies that you need them to sign off and approve your plan and do that. So they speak the language for someone who may not, and they have all those relationships and all the things that a fiduciary should be able to rely on as far as a professional on how to get from here to there and what to protect for. So while we didn't plan on plugging this so much, I will tell you in my own experience as a bankruptcy lawyer, the environmental specialists have been instrumental in getting from here to there, from getting from here to a deal.
And Sharon, sorry.
Yeah, no, go ahead, John.
No, I was going to say, and they're probably, from an insurance and underwriting perspective, the probably the single most important, I guess, partner you would have in evaluating the risk, not just from a historical perspective, but what was there, which is really important to the underwriters. But, they draft the reports, and the underwriters, what they're looking at is they're not doing physical inspections. So the only basis they have is that report to be able to provide terms for policy. So it's really, really important that that environmental consultant plays a critical role. And, the phase one is, also done appropriately to make sure that the policies that we obtain are, as broad as possible.
Excellent. So let's move to the sale. So let's go to the probably the biggest issue for all of us is monetizing the asset and paying their lawyers. Just kidding, paying the creditors. So let's Todd, go to the next slide.
There you go.
Yeah, keep going.
Sorry.
Okay, here we go. All right, so the magic bullet and one of the best protections you can get in a bankruptcy case is being the buyer of an asset, because that magic order allows you to get the asset free and clear of all liens. It is probably, I would say, in my opinion, probably the number one reason why most sales that are complicated in any sense are done through a bankruptcy case, because they do two things. It tries to avoid successor liability, and it provides a valuation method that no one really can dispute. Now, I'm using broad terms because obviously there's things in newspapers that don't follow what I'm about to say. But generally speaking, this is the benefit of doing a sale through a bankruptcy case. But even before you get to a bankruptcy case, there are ways that a buyer can buy property without the environmental liability, or at least having a way to deal with it. And Erin, maybe you could just talk briefly on how it normally works, and then I can insert where a bankruptcy case can even give enhanced value.
Yeah, thanks, Sharon. So let's take an old gas station, for example, and you have someone unrelated to the current owner comes in and they want to buy it. Our first advice would be to get an updated phase one that is ASTM compliant. And good consulting firms, and I would count Tim's among those, they will do that. The thing that you have to watch out for is ASTM compliance is really, really tricky. I just worked on a litigation matter where the phase one report was not compliant, and our client got sued. They're in a court setting. They want to hold up the phase one report and say, well, we're a bona fide prospective purchaser. And unfortunately, we had to tell them you're not, because the phase one didn't meet all of the checklist. So I can't underscore this point enough. If the phase one report isn't compliant, you get none of these defenses. All of these defenses come from all appropriate inquiries, which requires the compliant phase one report. So in a standard asset acquisition, that is our first and best line of defense here in the US, and that is always going to be a recommendation to a buyer. So on the seller side, anticipate that the buyer is going to want that process. Again, it doesn't require environmental sampling, but it would take at least 30 to 45 days lead time. So Sharon, what's the bankruptcy?
Right. So that's where I think all of this fits nicely, right? Because under non-bankruptcy law, that bona fide prospective purchaser status is the gold standard. That's what you need so that your buyer does not have successor liability. That's going to affect valuation on both sides. That's the gold standard. So what does that mean? It means that selling the asset where you have a court order that makes specific findings on whether or not you're a bona fide prospective purchaser is going to be helpful. Whether it's done in a plan, whether it's done through an asset sale, the nicest thing about having a formal proceeding is the ability to get those findings. That is, so you have the double protection, you have the 363 order, and you have specific findings entered that are final that allow you to enjoy that status as a BFPP. So if you go to the next slide, this is the test to be a bona fide purchaser under non-bankruptcy law. So you have to acquire the property after January 11th, 2002. We should be past that at the moment. You have to do all the inquiries, right? There should be a finding that you did all the things that Erin just told you to do. You got a compliant report. You didn't put your head in the sand. You're going to take reasonable steps to prevent the future release of hazards, and you're going to comply with land restrictions. So when I see a list like this outside of bankruptcy law, to me, it is a bright line of why a court proceeding is beautiful here, because you can get these findings, as Erin has said, is so important to this process.
Sharon, let me ask you,
Yeah.
I just interrupt real quick.
Go ahead.
How would this apply if for a receivership?
I think you would have to also get it in your receiver order, right? I think the problem with every insolvency issue, like the different types of insolvency issues, is money versus certainty, right? So an out-of-court workout theoretically may cost less. I say that theoretically because usually they cost more, but there's a high degree of risk because it's just a settlement, it's just a deal. Assignment for the benefit of creditors has some protections, but you don't have, especially if you're doing a California ABC, you don't have those court findings. Receivership at least is under a court supervised process, and you can get a court order for the sale order to get these findings. I always think of bankruptcy of having, it's probably costs the most. Theoretically, it probably costs the most, but it also comes with the highest degree of certainty because of the federal statute, the 363M finding of good faith. So bankruptcy is the only tool that allow a buyer to have this federally recognized protection. But a receivership, all of them can have it. It's just the matter of decree. And at the end of the day, your buyer's going to dictate what they want.
Yeah.
To me, this is always something that the buyer dictates. It's not, I mean, yes, we do find ourselves in cases where a formal proceeding is filed one way or the other. But a lot of times when you're doing this when you're in the planning stages, when you're trying to sell the asset, the buyer's going to tell you, I want this. And then the decision is a lot easier, in my opinion.
Erin, I had one quick question. Are you also protected from state as well?
Depends on the state. I know everyone hates that. It sounds like a lawyer's, but it depends on the state. Each state has its own, I would say most states have their own mini super fund. So check those. There are specific nuances that some states have. Michigan, for example, has a baseline environmental assessment, which is like a phase one, but is different. So there are state corollaries, John, and that is something to pay attention to.
I want to just hit quickly on some of these mitigation tools that happen both in bankruptcy and out of bankruptcy, because this is where John is going to become central. So as we said before, one of the biggest things you have to do is have a plan. What are you going to do going forward? How are you going to contain the risk, and how are you going to either contain it or prevent it from happening? And this directly impacts the value of the property one way or the other. One of the ways to deal with that is to have what is in bankruptcy speak, a liquidation trust. In environmental speak is a remediation trust. And this is where that plan comes into play, so that there's assets that are funded in the trust, there's a trustee, and the remediation actions can flow through that. There's other tools, and I want to just, I'm so excited about this issue, so I'm speaking fast because I really want John to talk about how insurance can provide some really important protections here that can be part of this solution, part of a trust, part of a going forward plan with the government. And with that, I'm just going to be quiet and let John do his magic.
Think next slide.
John, I don't know if your slides are in here.
Oh, okay. Fine, then. I will just go ahead and speak, and if anyone has any questions, please let me know. I think, we talked about a lot of the costs associated with and the risks associated with, environmental issues. And what are they? They can be first party, they can be third party claims, they can be regulatory or legal, and then you have ongoing business risks as well. So if we think about some of the first party sort of exposures or risks that we'd want to try and capture and mitigate, we have cost overruns is one. So you have a known contamination, a known cleanup, so we're trying to cap those costs. So that's an exposure if the costs exceed the expected amount. You always have questions surrounding unknown conditions, especially when properties are, former industrial use, or, you could have different commercial uses where the property was developed on land that was previously contaminated. And then you have third-party potential claims. You can have issues associated with loss of use or diminution of value. So if you have a property that you currently own, and there was contamination that migrated through the property onto a neighboring property, you can receive claims for property damage, if they couldn't use the property, or if there was some type of diminution of value because of that environmental contamination. And also, which is equally important, I think, especially in certain states, California being one, is claims for third-party bodily injury and property damage. So this is all a result of any type of pollution incident that, that occurred on your property. So from a regulatory perspective, and I mentioned all of these, it's almost like a list of these exposures that I'm mentioning, but these are all that are intended to be covered under an environmental policy. And I'll quickly go over the two environmental policies, which I think would apply to these types of situations. But from a regulatory and legal perspective, you have, a government mandated cleanup. So, regulatory agency mandates that you do an investigation or cleanup. You can also have exposures associated with like fines and penalties. And, in California, you have, oversight costs from the regulatory agencies, which are also included in, as a protection under the environmental policies. And for ongoing risks, you could have some type of like business interruption, or especially on development properties, you can have increased development costs as well. So those are kind of all of I know we talked about a lot of the exposures, but those are some of the exposures / coverages that would be provided under a pollution legal liability policy. So I'll talk about the two policies that really apply. One is a liability policy and what we call pollution legal liability policy, and or PLL for the acronym, it's short for PLL. So you have what we have, the primary coverages associated with that are cleanup costs for unknown conditions. We have coverage for bodily injury and property damage, as a result of a third-party claim. And we can insure and legal defense, obviously, since, for Erin and Sharon, but, legal defense costs are also included. So these policies are very broadly written. And what they do is, and these are all heavily manuscripted policies, which means, there's a specimen policy, but the specimen policies are usually, reviewed and then manuscripted. The language is changed to better fit the risk of the property and of the transaction. So, it's rare that you get a policy and, no changes are made. there's a lot of endorsements and a lot of negotiating that goes back and forth with the underwriter to make sure that the policy is meeting the expectations of not just the insured, but it fits the actual transaction as well. So, one really important thing to note is, when we're talking about environmental, we're talking about things that are below ground. And what you'll see a lot of times is, you'll hear terms referred to as like pre-existing conditions or new conditions. And this is really where the environmental consultants, as Erin mentioned earlier, is really critical in help determining what the policies look like. So they'll do the phase one reports, and after the probably one of the most important aspects of the phase ones from an underwriting perspective is, if we're not dealing with a glaring issue, is what was there beforehand. So it's really important that the environmental consultants focus on the pre-existing sort of potential pre-existing issues that arise out of the use of that property. And so it's really, again, it's really important to have that identified. And that's probably one of the critical aspects of when an underwriter is reviewing these reports. It's that, and it's the recommended environmental conditions that the phase ones will identify. And the underwriters are really focused on those two keys, or the recognized environmental conditions and the pre-existing. The operational exposure is more of, an issue that they feel like that can be controlled going forward. The second policy I wanted to quickly mention, and I wish we had the slides up, but we don't. So if this is too confusing, please just reach out and let me know if you have any questions afterwards. But there's a second policy. This isn't a liability policy. It's a cost overrun policy. And this policy is solely geared towards insuring against a known cleanup. So for example, if you have $1 million cleanup, the policy will provide coverage in excess of that $1 million and in excess of a deductible. So you would have the known cleanup at $1 million, for example. The underwriters would review what the consultants put together and the engineers put together in terms of the cost, the remedial approach. They'll determine whether or not this was a approved cleanup by the regulatory agency. And so they'll take all that into consideration. And if it's $1 million and they're comfortable with that number, and they feel like the remedy would come in at around that number, then they'll usually put on a deductible on top of that. So for example, they may say, okay, it's $1 million, but we need you to have some skin in the game as well. So we'll add on 100,000 or 200 or 300,000, depending upon the risk, what we call a buffer, so that you would have to go through that deductible in order for the insurance to apply. And this policy, again, it's not a liability policy. It's only insuring for the known cleanup and any overages that you may have for known remediation. But this is always combined with the pollution legal liability policy that I just mentioned, which provides sort of like the liability protection and insures against the unknown risks as well. So you have this cost overrun policy that insures against the overages of a known remediation. And then you have the PLL, or the pollution legal liability policy, that affords protection for any toxic tort third-party claims, as well as any cleanup of unknown conditions.
Yeah, and I mean, in my humble opinion, this is so important, because one of the biggest negotiating tools people use one way or the other when they're buying an asset is all these unknown factors, right? This quantifies the liability. This, I mean, whether you're in bankruptcy or not, if you can get this policy and it's going to cost X, you've now quantified that risk or that devaluation of the property, and that conversation now is over, right? Because you have a number that you could fill in the blank for, and it shortens the negotiation room, or it shortens the unknown, so everyone's on a good playing field. And so the fact that you can cap liability for what you know, and the fact that you can insure what you don't know as part of a sales transaction. I mean, I, again, I just see this as so important, just like you would have insurance for other things. And when I represent fiduciaries, which I do, whether they're debtor in possessions, I represented trustees. The biggest thing that you care about are your sources and uses of assets. So this now becomes a resource later on if you're in a case or you have a property that had this insurance. It's also something you can take advantage of. So I think this is an amazing tool that people should be well aware of.
Sharon, from a sale or valuation standpoint, that's one of the components we will ask for upfront, especially because the appraisal process for us is generally the first thing done out of the gate. And is that going to be provided or not? What can John provide? What is the scope, and how will we take that into account for that? And you remember there's different types of values: as is value, hypothetical value, or or even in some cases retrospective. So that is a component to the valuation. And as I agree, very, very important. And even more important on the selling side, because if you have that going into the appraisal, then the appraisal valuation, assuming it's used to determine some sort of sale value, then the brokered or auction sale that we would do would be taking all that into account. And John, yes, we will.
One thing I did,
Go ahead.
I did just want to mention one thing, and I think it's important, for the audience here, is that, these policies are assignable, so they can follow the property to a new buyer. So regardless of who takes out that policy, as long as it's approved by the underwriter, you can assign these policies so they can kind of move forward throughout the timeline with a new buyer.
Agreed. We're past the hour. I don't have any questions in the chat. And I have to say, this has been a very, very interesting presentation. And candidly, I think there's probably one for us to do a follow-up on different components of these of this presentation. We will have an updated presentation available on the fiduciaryforum.com website that'll take into account some of the things John has been speaking about. And I want to thank John and Sharon and Erin for being so kind with their time and to make this presentation for everybody. Our next Fiduciary Education Forum presentation will be next Tuesday, the 13th of January, and that topic is quite interesting. And the title is Missed Opportunities Acquiring Real Estate and Business Assets Outside of Court Supervised Situations, Knowing What to Do and Who to Deal With. That is our topic next week, noon Pacific time. And so I want to thank everybody and our viewers. Again, you'll be able to view this presentation at fiduciaryforum.com. It'll be up there as well as this updated presentation. So thank you, Sharon. Thank you, Erin and John, for participating. And I want to wish everybody a happy new year and a healthy and prosperous new year.
Thank you all so much for
everyone.
listening. And thank you again, Todd, for the opportunity.
Thank you. And we will have a follow-up, I think, in the first quarter. We'll talk with everybody about doing this. So thank you, everybody. Signing off. Happy New Year. Thank you so much.
Thank you.
Happy New Year.
Thank you.